So now we're going to go over the most common and the most recommending type of package for divorce I would do. It's called uncontested. It's not default, meaning you filed, the other spouse filed, you exchange disclosures, you both filed proof of service of disclosures, and you have a written agreement. And this is not including children. So let's look at the judgment checklist so you understand which form I'm going to go over right now. The judgment checklist includes uncontested case, response filed, and other appearance by respondent or other appearance. If response is filed, it's fine. If other appearance means you had a hearing and a written agreement. So proof of service was discussed in another module, FL115. Then we will file FL130 and respondents filing fee if first appearance unless respondent has fee waiver, meaning basically respondent who filed FL120 needs to pay $435 unless there is a fee waiver. Then declaration regarding service of disclosures, meaning both petitioner and respondent have to file FL141. Then, which means you served each other financial disclosure. Then declaration regarding a final declaration of disclosure. So either you file again 141 where you check off final, or it says or, you see, stipulation and waiver final declaration of disclosure. So what it means is you don't have to serve each other if you're divorcing in a short period of time. Even if it's a long period of time, you can waive to not have disclosed financial disclosure for the second time after you have been going through divorce for a while. Separately filed waiver or waiver including in the written agreement under family code section. So this is something that I have in my agreement that you can copy paste. And then here, declaration for default or uncontested, the form FL170, then written agreement, judgment, and FL190. So easy. Let's go over it. And this is how you're going to fill out these forms. Same caption as in every other form. I have previously made a general appearance in number 1. You check off in 2, 1, 2, 3, 4. The parties agree that this cause may be decided in uncontested matter. 2B, the parties waive their rights to notice of trial, statement of decision, motion for a new trial, and right of appeal, which means it's uncontested. You don't want to appeal anything. C, this matter may be decided by a commissioner sitting as a temporary judge. Sometimes judges are sick and they have some temporary judges. And 2D, the parties have a written agreement that will be submitted to the court and attached to FL180. Then signature of petitioner, signature of respondent, date, type your name. Don't forget, if you have lawyers, that would be me. I would be signing here, and attorney for respondent. Now, the form FL144 is the final declaration, final waiver of final declaration of disclosures. Both of you will sign here, type in your name, date. So this is keeping FL141, which you can watch in the video about PDDs, which I assume FL115 and FL141 has been filed before. And if not, if you file everything at once, then you got to go to another module about about preliminary declaration of disclosures. So now FL170. Again, caption the same, declaration for default and uncontested dissolution. All information in the petition is true, and we check uncontested in 4C. And then page 2 on FL170 on top, this matter is proceeding as uncontested action, service of final declaration of disclosure, which is form FL144, not 140. Is mutually waived by both parties. A waiver provision executed by both parties under penalty of perjury is contained on the stipulation waiver final declaration of disclosure, FL144. Okay, so this must be FL141 then, and this is 144 because it doesn't make any sense. Either way, we file FL-141 and FL-144. Now, spousal support is in written agreement. And then I would presume that you would, read what needs to be checked off for your case, but I'm going off an uncontested, not asking for anything kind of case. Then you petitioner sign here, date, type your name. 190 is a little bit blurry, but the same caption, check off dissolution, and on the bottom, your name and respondent's name. 180 would show, this is the final form that you will show that you're single, dissolution, and judgment on reserved issues. I don't check this off. It's usually in cases where we first had status only and then moved on. Status only meaning we just declared each other single, and then we moved on to dividing our assets. Basically, if you're an uncontested case and you haven't been appearing, you just dissolution, remove that one. And here the court will fill in the date, and the date is December 31st, 2020, which should have been here. This proceeding was heard as follows: uncontested, or by declaration, the date the marriage ends is this date, and the judge puts a date, unless you want to put a date, but it cannot be less than 6 months and 1 day from the time you served the other side. Very important, number 3, not forgetting this other date when the other person was served, which is in the form FL-115, but people forget in judgment packages get bounced. The respondent was served, was processed, which means was the petition package. The court orders in good cause appearing that the judgment on reserved issues, because we have an agreement. Spousal support C agreement, property division C agreement, attorney's fees C agreement, and other court reserved jurisdiction over funds from some property until fully distributed. And then the date, the signature, and that's it. So now we have marital settlement agreement. So we have a caption, petitioner, respondent's name, court, case number, and you fill in your information. The purpose of this agreement, to make it final, effective date when each last party signs the signature. Then we have parties' facts, how long have they been married, and then clients' names, and then they waive it all, and then property awarded to one side, property awarded to another side, and this can be very, very long. So I'm going to attach a sample of an agreement. You can see how many pages it can be. It can be 28 pages as a Word document, so you can use whatever provisions applying to you. And both of you would need to sign it. You don't need to have it notarized. So because this is an uncontested, not a default, respondent doesn't need to notarize it. So you can both sign it and send original copy plus 4 other copies to the clerk, and make sure that each form has 2 copies. Send it in an envelope to the court with return address to you and respondent, with postage so that the clerk can approve it and send it to you. All right, that's it for today.